On behalf of the Metro Denver chapter of the Freedom from Religion Foundation, I would like to thank Eddie Tabash for traveling from California to speak to us today on the topic, the true meaning of separation of church and state. Eddie Tabash is an attorney in the Los Angeles area. He graduated magna cum laude from UCLA in 1973 and obtained his law degree from Loyola Law School of Los Angeles in 1976. Eddie currently chairs the National Legal Committee of Americans United for Separation of Church and State, an organization devoted to preserving equality before the law for both believers and non-believers. He also currently chairs the board of directors for the Center for Inquiry, CFI, as it's known, a prominent secular, humanist, and scientific skeptic organization. In an interview, Eddie asserted, "No American can officially be valued more or less than anyone else because of either adhering to or rejecting a tenet of religious belief or non-belief. The separation of church and state is one of those magnificent issues that can help to unify a very severe division in our country because its aim is to protect both believers and non-believers equally." Please welcome Eddie Tabash. Thank you very much.
I want to thank the FFRF chapter, an organization of which I'm also a life member, for bringing me in to speak. I want to thank Becky for the enormous amount of effort she put in to making this event possible. What I'm about to tell you, what I'm about to talk about requires some basic definition before I begin. Our purpose today is not to promote atheism per se, though that's what half my life is spent doing. Our purpose today is to promote what the other half of my life is spent doing, which is preserving the separation of church and state, which I define as no branch of government being able to favor believers over non-believers, no branch of government being able to impose any legal disability on any human being because of either accepting or rejecting any tenet of religion. Now, in the course of my presentation, I will have to single out certain individuals from one political party more than another because of the dominance of that party by the religious right. However, all of the three organizations involved in today's presentation are 501c3 nonprofits, which means we are nonpartisan. Mentioning the reality of what one political party does is not speaking out against them in general. And I also want to make the comment, because it is my objective to broaden the base of secular people, that my attack today, though it can be deemed a liberal one in the parlance of American jargon, is not a condemnation of conservatism in general, because if you're a true conservative, you should oppose the religious right because they represent the most intrusive and invasive form of government intervention into our private lives. It is my goal that within 20 years or so, if someone stands up and says, "I'm a church-state separationist," or "I'm a non-believer," from that alone we would not be able to tell where they stand on any other political issue. It's my aim to so universalize our movement that people who disagree from all sorts of different issues can come together on the importance of secular government. I will, because of the nonprofit status, be speaking in code about the presidential election. And I will also be reminding those of you in this state that the Supreme Court is determined not just by having the right president in the White House, but by having a United States Senate that will reject religious right-wing justices and that will confirm the appointment of church-state separationist justices. There's no question as to what those of you who care about secular government should do with respect to this state's current U.S. Senate race. Just please remember to do it in 2 weeks. And so now I'm going to begin by more or less following what you have in your outline. And what I'm going to do at the commencement of my presentation is to show you something remarkable. Even though the history of the founding of the First Amendment is very sparse, even with that minuscule record, we have a remarkable amount of evidence that the framers explicitly intended a government situation in which believer and non-believer are supposed to be equal, and the record is so strong that it demonstrates how false the religious right-wing legal scholars are and their judges are when they say that government can only not discriminate among religions, but can combine with all religions to oppose non-belief. No one needs to tell you that given the precarious balance on the Supreme Court, and it is the Supreme Court that determines whether we have church-state separation or whether we have a theocracy, that at this time in America today, we stand on the threshold of two possible futures. One future is one in which a reconstituted Supreme Court will affirm the dignity of everyone in the country, regardless of their views on matters of religion. The other is one in which government will be freed to openly favor theocratic belief systems and impose them on society at large. We have a very, very dangerous national election in the next 2 weeks. There is not a single state that we can afford to lose. And remember, never, ever take comfort and solace in polls that you may seem to like, because the only poll that counts is what happens on November 8th. And we have to all bear this in mind, because whether or not the Supreme Court will be remade in the image of church-state separation and secularism or remade in the image of religious tyranny will be determined by the American people in 2 weeks. Now, as I give you the history of the First Amendment, and then after that I will take you through what I call the list of horrors of the religious right of the past 35 years, I want you to keep one dominant theme in mind, and that is the framers, remarkably so advanced for late 18th century people, had uppermost in their minds the preservation of protecting the rights of conscience for everyone. Throughout the work of Madison and Jefferson, and Jefferson was indisputably the greatest influence on Madison in terms of church-state separation, and Madison was the principal author of the First Amendment, you will see that they and other members of Congress had uppermost in their minds protecting the right of conscience. Prior to ideology, prior to theology, prior to any other consideration, the foundational concern of the founders was that everyone, be they believer or non-believer, would have their rights of conscience protected. And this remarkable, enlightened, advanced view for the late 18th century pervades the history I'm about to give you. When the 55 authors of the original Constitution gathered in Philadelphia in 1787 to draft the Constitution itself before the Bill of Rights, they wouldn't pray for guidance even if their deliberations were stymied. Also, there was only one reference to religion in the original Constitution, a negative one, Article 6, Clause 3, prohibiting any religious test for public office. And when debating this, even a future Supreme Court Justice, James Iredell, supported the prohibition of any religious test, and said if we value religious liberty, we must allow pagans and those who have no religion at all to be elected to office. Why? Because high-ranking government officials at the founding of our nation were so enlightened, once again, protecting the rights of conscience. This is the unbroken thread that the religious right cannot refute because the historical record is clear. Now, 4 years before drafting what was the first draft of the First Amendment, James Madison wrote a memorial and remonstrance against assessments in his native Virginia that would have funded all the clergy. And what he said, specifically with respect to Christianity, is remarkable because this is the principal author of the First Amendment. So if anybody wants to say America was designed to be a Christian nation, they have to overcome the words of the main author of the religion clauses of the First Amendment. And in 1785, James Madison himself, the future fourth president of the United States, wrote, "During almost 15 centuries has the legal establishment of Christianity been on trial. What have been its fruits? More or less in all places, pride and indolence in the clergy, ignorance and servility in the laity, in both superstition, bigotry, and persecution." Someone who had such a negative view of Christian-run government would not have designed the American constitutional system to be an officially Christian nation. Then in 1786, to cement the argument that Jefferson and Madison had identical views on the question of religious liberty and question of conscience, while Jefferson was in Paris, Madison secured the passage of the Virginia Statute for Religious Freedom through the Virginia legislature. Later on, in 1821, in his autobiography, Jefferson exulted in the fact that the effort to dilute this bill to protect only Christians was defeated, and Jefferson said that he was delighted that the bill that he and Madison had passed in the Virginia legislature in 1786 protected everyone, including the infidel of every denomination. If you are protecting the infidel of every denomination, you are not establishing a Christian nation, and you are not establishing a nation in which atheists and other nonbelievers and religious dissenters can be second-class citizens. After this bill was passed, Madison wrote to Jefferson that this law has, in our country, extinguished forever the ambitious hope of making laws that restrict the human mind. Once again, the unbroken thread, the theme, protecting the rights of conscience. Now, Jefferson himself was certainly no practicing Christian. He was a deist. In October of 1819, in a letter to William Short, he totally rejected any supernatural stories about Jesus. And in April of 1823, the retired third president of the United States, Thomas Jefferson, wrote to the retired second president of the United States, John Adams, "And the day will come when the mystical generation of Jesus, by the supreme being as his father in the womb of a virgin, will be classed with the fable of the generation of Minerva in the brain of Jupiter." Thomas Jefferson is saying that the concept of the Immaculate Conception and the virgin birth is as outlandish as ancient Greek and Roman mythology. Then in 1785, in writing to General Alexander Smith, Jefferson was discussing the book of Revelation. He called it merely the ravings of a lunatic, no more worthy or capable of explanation than the incoherence of our own nightly dreams. So thus far, what Jefferson is showing to us is that for us, a majority of whom I think in this room are non-believers like me, we can promote our ideas, we can promote our philosophy, but we call upon the legal system to treat everyone equal before the law the religious and the non-religious. Once again, the unbroken theme, the right of conscience. Now, nowhere does the combination of Jefferson and Madison more thoroughly cement this concept of protecting the right of individual conscience, regardless of where the individual winds up on the theological spectrum, as in Note 17 to Jefferson's Notes on Virginia, published in 1787. He wrote, "The legitimate powers of government extend to such acts only as are injurious to others." What does that mean? It means that unless you physically harm someone, the expression of your ideas cannot be punished. But then the future third president of the United States goes on to say, "It does me no injury for my neighbor to say there are 20 gods or no God. It neither picks my pocket nor breaks my leg." Once again, the Jefferson-Madison team is saying that regardless of whether you stand on the theological spectrum, be it atheism, belief in one God, or a multiplicity of gods, you're not hurting anybody. Government should not impose any legal impediment upon you. Now, the other thing that we see from both Madison and Jefferson is an aversion to clergy having government power. Jefferson used the phrase priest to refer to all clergy. And in 1813, a letter to Alexander von Humboldt, he said, "History, I believe, furnishes no example of a priest-ridden people maintaining a free civil government. This marks the lowest grade of ignorance of which their civil as well as religious leaders will avail themselves for their own purposes." And then he also wrote to Horatio Spafford, "In every age, in every country, the priest has been hostile to liberty. He is always in alliance with a despot." Once again, Jefferson is saying you cannot trust clergy to run government. If you can't trust clergy to run government, you can't trust those who take their orders from clergy. He also wrote to his nephew Peter Carr and said, "Question with boldness even the existence of a God, because if there be one, he must more approve of the homage of reason than that of blindfolded fear. And don't be frightened from the inquiry by fear of its consequences, even if you find that it ends in a belief that there is no God." Once again, Jefferson, the primary influence on Madison and religious liberty, is trying to create a national understanding in the new country that everyone is equal in society and before the law, regardless of what type of God or gods they believe in or don't believe in. And then we see a year before drafting the First Amendment, Madison echoing this position in Federalist Number 52, where he urged the nation to ratify the Constitution, including prohibiting any religious test for office. Madison wrote, "Merit of every description should be allowed to seek office without regard to any particular profession of faith." So the founder, the primary founder of our First Amendment, wants everyone to be able to seek office without worrying about what religion they subscribe to. Then, in October of 1788, Madison, in a letter to Jefferson, expressed concern that the people would deny infidels the right to hold office and the majority would narrow the rights of conscience. This is irrefutable proof that James Madison wanted us non-believers and believers in any and all forms of belief or non-belief to be equal before the law, so he could not have possibly drafted and shepherded through Congress and sent to the states a measure that would have protected only the religious believers. Now, in June of 1789, Madison had his first draft of the First Amendment, preventing the government from abridging civil rights of anyone because of religious belief or worship, and prohibited infringement upon the full and equal rights of conscience, and of course can't establish any national religion. But to show you once again the magnificent thread the unbroken trajectory of protecting the rights of conscience of everyone in this country. As the House was debating this measure before sending it on to the Senate, Representative Daniel Carroll, one of the original signers of the original Constitution, said in the debate, "The rights of conscience are, in their nature, of such peculiar delicacy that they will little bear even the gentlest touch of government hand." Once again, protecting the rights of conscience as an unmistakable, pervasive theme. And here comes the most powerful proof against the religious right-wing claim that government is permitted to favor all religions, just can't favor one religion over others, but favor all religions, but disfavor non-belief. If that were true, there were two proposed wordings put before the Senate when it was considering what was to become the First Amendment that were rejected on September 3rd of 1789. If one of those two wordings were accepted, then our side would not have the argument we do today. But the fact that they were rejected is, again, concrete proof, rejected and never brought back, that Congress considered and rejected all efforts to just prohibit government from favoring one religion over others, but allowing government to discriminate against the non-believer. One proposed wording said, "No law establishing one religious sect or society in preference to any other." Another proposed wording, "No law establishing any particular denomination or religion in preference to any other." They were both rejected and never brought back. And so when the Senate and the House had a conference committee to reconcile the competing versions, Madison was the chair. And the result was the Establishment Clause that finally read, "No law respecting an establishment of religion." Not even no law establishing religion, no law preferring religion, no law that can even show respect to an establishment of religion. Now, since Madison was the principal author and Jefferson was his main influence, the writings of both of them, even afterwards, give us a window into understanding what they meant. Jefferson, in 1802 as president, talked about building a wall of separation between church and state. Jefferson, as president, refused to issue Thanksgiving proclamations because he felt they were unconstitutional religious exercises. So just think, the president elected in 1800 was truer to the purpose of the Constitution than modern presidents. This is really remarkable and surprising. Madison, in 1817, 18 years after introducing the First Amendment, in his detached memoranda, opposed tax exemptions for property already owned by religious institutions. This is not someone who drafted the First Amendment to give the religious special rights unavailable to anyone else. But we saw, with the rise of the religious right in the 1980 elections, a new phenomenon. We saw an effort by a powerful lobbying group, sometimes representing up to 1/3 of the total voters in this country. We saw this very, very powerful effort to turn America into a theocracy. Ronald Reagan, as president, in addressing the Alabama legislature in 1982, said, "Sometimes I can't help but feel that the First Amendment is being turned on its head. The First Amendment was not written to protect the values of this country from religious values. It was written to protect religious values from government tyranny." Well, I'm sure Reagan didn't think this through, but if we, the people, are not protected from religious values, how far can government go in imposing religious values on us? This is very dangerous. Also, in 1984, his re-election year, Ronald Reagan said, "America needs God more than God needs America. If we ever forget that we are one nation under God, then we will be a nation gone under." What does this say to those of us who don't believe in any God? And then in 2004, the Texas Republican Party reaffirmed the United States as a Christian nation, called church-state separation a myth, and called for abstinence instead of sex education. When meeting with the Pope in June of 2004, President Bush asked the Vatican to actually push American bishops to be more aggressive in efforts to ban abortion, and at that time, a constitutional amendment against same-sex marriage. In July of 2004, his re-election year, President Bush told an Amish crowd, "I trust that God speaks through me. Without that, I couldn't do my job." Now, even if you are a believer in some kind of higher power or deity, you may not necessarily want a president who believes he's channeling the ultimate force in the universe, because that means that that president will consider his views to be infallible, because they are coming from the most powerful ultimate force to be even conceived of. And that can be dangerous for not just us non-believers, but even believers and even members of minority religions. Again, if you are a true conservative, you would not want the government to assert control over issues of birth, life, death, sex, health, marriage, medicine, and the role of the family. Today, we are not only fighting over the preservation of abortion rights, even the right of access to birth control is at issue. Today's religious right and their justices on the Supreme Court opposed the 1965 case of Griswold versus Connecticut, where the Supreme Court prohibited the states from barring married couples from using contraception. Now, just think of what it would mean to have a Supreme Court revised by a religious right-wing president that now says the states are free to prohibit married couples from using contraception. The religious right equally opposes the 1972 case of Eisenstadt versus Baird, in which the Supreme Court declared that unmarried individuals have a right to use contraception. Again, what's frightening here is we're not even speaking about abortion. We're going back to the fights over birth control of the 40s and the 50s. 40s and the 50s of the 20th century. There's also an assault on public education. There's always been an assault on public education by the religious right, because high-quality public education will churn out generations of Americans who, the more enlightened they are, will either not accept religious fundamentalist views or certainly will not accept the imposition of religious fundamentalist views on their neighbors through force of law. One of the founders of the religious right, Jerry Falwell, wrote in his book, America Can Be Saved, "I hope I live to see the day when, as in the early days of our country, we won't have any public schools, the churches will have taken them over again, and Christians will be running them." Also, if we lose church-state separation, creationism and intelligent design will be taught along with evolution, or even in preference to it, in our public schools. In May of 2001, President Bush stopped federal funding for stem cell research. This is something that has put America behind in modern biotechnologies. Even former Missouri Republican U.S. Senator John Danforth said that this will unnecessarily deprive many millions of people of the advances in medical science that they need. Right now, though our side prevailed on decriminalizing private sexual acts among persons of the same gender and on the right of persons of the same gender to marry each other, this would hang by a thread on the Supreme Court if there are two more justices appointed by a religious right president and confirmed by the Senate. Because with a shift of 2 votes, there will then be the 5-vote majority to overturn these. and the states will not only be free to no longer recognize same-sex marriage, they will be free, as they were before the 2003 case of Lawrence versus Texas, of criminally punishing consenting adults who do no more than express physical love for each other. The leading religious right confidant of religious right presidents when it came to the Supreme Court has been the very extreme Pentecostalist preacher Pat Robertson. In March of 1990, on his 700 Club program, Robertson said, "Many involved with Hitler were Satanists. Many were homosexual. The two things seem to go together." We never want a president who will allow someone like Robertson to whisper in the ear of the commander-in-chief who to put on the Supreme Court and who not to do so. We succeeded a number of years ago in having Roy Moore removed as Chief Justice of Alabama from its Supreme Court because he refused a federal court order to take down a giant Ten Commandments display in the courthouse. Once again, we just had him suspended from being Chief Justice because he ordered lower court judges in Alabama to refuse to permit same-sex marriages from going forth, even though it's now national law. But before his first removal, Roy Moore, the Chief Justice of one of our 50 states, writing in a concurring opinion denying a lesbian mother rights of custody, said, "The state carries the power of the sword, that is, the power to prohibit conduct with physical penalties such as confinement and even execution. It must use that power to prevent the subversion of children toward this lifestyle. I submit that the Chief Justice of any of our state Supreme Courts absolutely has no business of condemning gay people in the same paragraph where he speaks about the use of execution. This is something that is highly, not only dangerous, but it opens the chasm of a kind of retrenchment to a backward theological tyranny that our country has never even seen. The abstinence-only sex education has been a disaster in the United States. The Washington Post reported 12 years ago that many young people in federally funded abstinence-only programs have been taught that abortion leads to sterility and suicide, and that half the gay male teens are HIV positive, and that even touching a person's private parts can lead to pregnancy. If the latter were true, a certain prominent presidential candidate today might have more than 5 children. The faith-based initiatives have been not only unconstitutional, but they have damaged many people. And it is to the everlasting, I won't say eternal because I may not believe in that, but it is the everlasting credit of FFRF to have taken on the Heim case in an attempt to have this program knocked down, even though the Supreme Court issued a terrible ruling on the right of people to have standing to challenge First Amendment violations. Here's just one example. There was a shelter for homeless veterans in Northampton, Massachusetts. A third of its funding was lost after the government diverted its money to faith-based groups. And the shelter now no longer provides services for veterans. So here again, we see what happens when government comes into alliance with religion, as Jefferson and Madison warned us about well over 200 years ago. Now, right now on the Supreme Court, to be accurate, our side has 4.6 justices, their side has 4.4 justices. That means that whether we win or lose depends on Justice Kennedy. Every time we lose, Justice Kennedy goes with the religious right side. Every time we win, Justice Kennedy goes with our side. the president and the Senate that confirms the ultimate replacement of Justice Antonin Scalia will be playing a crucial role in the future of American official secular society, one way or another. In a 2005 Luckily dissent, Scalia wrote, "The principle that government can favor religion over irreligion is demonstrably false." So here, Justice Antonin Scalia ignored all the history that I just put before you, showing that government cannot favor anyone based on belief system. But then Scalia, in a very, very frightening manner, went a step further, and not only did he declare those of us who are atheists outside the pale of protection of our Constitution, he said that even those who believe in many gods or deists are equally unprotected. His exact words, "It is entirely clear from our nation's historical practices that the Establishment Clause permits the disregard of polytheists and believers in unconcerned deities, just as it permits the disregard of devout atheists." What kind of an America is it in which, because we don't believe in the right concept of a supernatural being, we're second-class citizens? But his colleague on the court, Clarence Thomas, who was still on the court, went a step further. In a most bizarre and twisted form of reasoning, Justice Thomas has said that the Establishment Clause doesn't even apply to the states. All the other provisions of the Bill of Rights do, but the Establishment Clause does not. Therefore, each state is constitutional free to have an official church. Just imagine the civil unrest in our society if each state could have an official religion and declare other religions to be secondary. In the 2012 presidential campaign, Newt Gingrich, who has without question been guilty of adultery and all sorts of types of conduct that are not in keeping with the religious traditions he professes, has said that he couldn't support anybody to hold office who didn't hold religious views. Does faith matter? Absolutely, Gingrich said. How can you have judgment if you have no faith? How can I trust you with power if you don't pray? Well, how do we trust him with power if he cuts out on a wife who's lying in a hospital bed after cancer surgery? I think this is a legitimate question for us to ask. Now, what I want to talk to you about is the most recent updates on what the religious right has been doing, and to show you, in a way that paraphrases Mark Twain, that unfortunately the rumors of the death of the religious right have been greatly exaggerated. They are still 1/3 of the electorate. For those of you in this very, very beautiful and wonderful state, remember, notwithstanding all the very, very committed and highly evolved, intelligent people in this room right now who'll be voting in 2 weeks, when it comes to the religious right, Colorado has been what we call a wobbler. It can go either way. Evangelicals are easily 1/3 of the electorate in this state. And you must keep that in mind as you help get out the vote in 2 weeks. In May of 2014, the Supreme Court, and again, 5-4, up to Justice Kennedy, issued a decision against us in Town of Greece, New York versus Galloway, in which they said that a town council can choose to have a succession of only Christian clergy give invocations, as long as they don't explicitly bar others just because of their belief or non-belief. So now town councils all over the United States can have only Christian clergy. This is something, again, that shows the worst form of religious preferentialism. The Supreme Court is in danger of losing the wonderful interpretation of church-state separation by Justice O'Connor, the first woman to ever serve on the United States Supreme Court, and one in whom in totality of her service on the court could be called a moderate to moderate conservative. And she said that government is prohibited from communicating the message to anyone that because of either accepting or rejecting any religious belief, they are outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders. So this is a very, very poignant way of expressing the concept of government neutrality, which is another way of saying we are all equal before the law. Now look at how benevolent we church-state separationists are compared to the religious right. We are not asking for greater rights than they have. We just want equal rights. And this is something we have to emphasize as we speak to society at large. In 2014, the Supreme Court decided, again, a heartbreaking 5-4, Burwell versus Hobby Lobby, where it said that even if a religious person runs a secular and non-religious business, doing business with the general public, in this case, hobby materials, that the owners of that business and the corporation itself can have a religious view opposing contraception and can deny its employees access to insurance that would cover contraception. And this was upheld by the court. Then, this year, because of the 4-4 split, in the case of Zubik versus Burwell, the United States Supreme Court deadlocked on the question of whether religious institutions, even though they don't have to provide insurance coverage for contraception, whether they even have to comply with the government requirement that if you're not going to give your employees insurance coverage for contraception, you just have to sign a paper to the government so the government and the employee can seek that coverage elsewhere. There were a group of Catholic priests and nuns that felt that even doing that was assisting the employee in obtaining contraception, and the Supreme Court remanded it to the lower court because of the 4-4 draw and couldn't even decide that it's not asking too much for religious institutions to just sign a paper saying, we're not going to provide contraceptive coverage, employee, government, get it elsewhere. We cannot give such enormous special preferential treatment to religion. When the Supreme Court decided last year that persons of the same gender have a constitutional right to marry, former Arkansas governor and presidential candidate Mike Huckabee asked people all over the country to defy the Supreme Court ruling on same-sex marriage because, in his words, the Supreme Court is not the supreme being. See, once again, what you see is there is no recognition of the difference between one's personal views and what these people think the law of the land should be binding all of us. They have no reservations whatsoever of using their theology to impose their views through the police power of the state on all the rest of us, notwithstanding that we're supposed to be a pluralistic society. In 2014, in Escambia County, Florida, some of the commissioners walked out on an invocation given by an invited atheist guest because they feared that it would be a satanic invocation. There was a city in Texas, in Alaska, that didn't want to allow an atheist to give the invocation but relented when they were threatened with a lawsuit. Now, very important for our purposes, and even those of us who are non-believers, we must protect the concept of church-state separation for everybody. The state of Florida, even though it had numerous religious displays in the Tallahassee state capitol, didn't want the Church of Satan to have any place. We, though we might laugh at this initially, we cannot accept a society in which the state discriminates against any group based on their views on matters of religion. And so if a state allows a religion that says you will go to hell forever if you don't believe our way to put their display up, but prohibits a devil-worshipping church from doing the same thing, it is a violation of government neutrality, and we must defend the rights of the Satanists equally with defending our rights. The principle must be uniform and must not have any exceptions. Now, the Pew Research Center showed in June of 2014 that 65% of Americans still believe the Bible is the inerrant word of God. As atheists, we want to educate people out of this. As church-state separationists, we say to them, believe what you want, but don't use government to impose this on the rest of us. A September 2013 survey showed that the percentage of adult Americans, at the time including Justice Scalia, who believe in Satan is very high. In fact, in that year, Justice Scalia said in an interview that the reason why many of us are atheists are really not our fault, but the devil has been tinkering with our minds. And he was serious. Okay, 64% of the people in the South fear the devil. 56% in the Midwest, 52% in the West, and the only place that's under 50% was the Northeast, but that's still at 48%. Once again, as atheists, we want to argue why there are no supernatural beings, gods or devils. But as church-state separationists, we don't want to harm, restrict, or punish those who believe this way. We want them to have the freedom to do so, but not to use the reins of government to impose this on the rest of us. Currently, the state school board in Texas wants to adopt standards for teaching history in the public schools that would focus on the influence of Moses, Thomas Aquinas, and get this, John Calvin on the founding of America. And this is something, obviously, that all our organizations need to fight. In August of 14, there was a state trooper in Indiana that was pulling people over and explaining to them they need to go to his church in order to be saved. The ACLU brought a lawsuit, and finally, in April of this year, the state of Indiana fired that state trooper. 2 years ago, the Air Force refused to reinstate someone who reenlisted but refused to take an oath under So Help Me God. Only after all our organizations pressured the Air Force did it let this person back in. Now, again, 42% of adult Americans in the United States believe we humans were created in our present form with no evolution whatsoever. On the atheist portion of who we are, we educate against that. On the church-state separation portion of who we are, we just tell them you are legally entitled to those views, but don't commandeer the power of government to impose this on the rest of us. Recently, the governor of Kentucky told pastors to break the law by openly endorsing candidates for office. Then the police chief of Bridgeport, Connecticut, asked the people of that city to fight crime through prayer. The governor of Oklahoma is urging people to pray for the oil industry. I don't think they need any help, prayer or otherwise. But this is just an example of what has been going on. Remember that what we are speaking of is a society in which religious dogma cannot be used by government to overcome science. So in Ohio, there has just been another bill introduced that would allow creationism to be taught in the public schools. For those of us concerned about reproductive freedom, abortion and birth control, last year, 2015, 53 abortion clinics closed in the United States because of anti-choice legislation in the various states and other forms of intimidation. Now, we, the United States, were never, ever meant to be a pure democracy. We are a constitutional democracy, one in which the majority cannot impose its will on the minority in certain areas like religion, secularism, belief systems. In 1943, Justice Robert Jackson wrote this marvelous encapsulation of the law for the whole country when he said, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion." It was former New York Governor Mario Cuomo who said it best in 1989, when he said, "It is rank hypocrisy for the religious right to lecture us on limited government and then to turn around and try to use government to tell us, the American people, what God to believe in and how to apply the judgment of that God to our bodies and to our bedrooms." Just before leaving the Supreme Court in 2005 and being replaced by Justice Alito, Justice O'Connor's last words to her colleagues and to us as a Supreme Court justice came in a concurring opinion where she wrote, "At a time when we see around the world the violent consequences of the assumption of religious authority by government, Americans can count themselves fortunate." And then she said to those who would weaken the separation of church and state, "Those who would renegotiate the boundaries between church and state must therefore answer a difficult question. Why would we trade a system that has served us so well for one that has served other nations so poorly?" She then reaffirmed government may not promote belief over non-belief. In 1962, in the case of Engel versus Vitale, the United States Supreme Court declared as unconstitutional formal prayers in the public schools. 90% of the American people opposed that decision. President Kennedy came out in favor of the decision and reminded the American people that everyone can pray at home or in church. But even more importantly, in the 1960 presidential election, when addressing a group of ministers in Houston, Texas, candidate Kennedy said, "I believe in an America where the separation of church and state is absolute." It falls to us today, secular and even moderate religious people, to make sure that the bullets that cut down President Kennedy on November 22nd, 1963, do not ultimately destroy that cherished vision of his, a vision to which we must all devote ourselves, of an America where the separation of church and state is absolute. Thank you.